Hey everyone, welcome back to another episode of Fear-Free Passive Investing, where we strive to be the number one source for passive commercial real estate investing education on the web, on YouTube, on the podcast. And today's episode is great because we answer a lot of legal questions that a lot of you have been asking. And we got one of the best people I know to answer some of these legal questions, and his name is Dugan Kelley. Now, Dugan and the firm that he co-founded, Kelley and Clarke Law, they handle a lot of different areas of practice. But today we're going to be focusing in on syndication, which is what these passive investments are. So if you're interested in syndication, if you've had legal questions like, should I invest with an LLC, or how is COVID impacting some of these negotiations, you're really going to want to tune in and listen for the whole episode. If you have questions, Dugan's information on how to get in touch with him is actually going to be at the very end, or at fearfreepassive.com if you want to get in touch with him. Now, today's episode is great, but you shouldn't take this as legal advice right away. You definitely want to get a personal consultation. You want to talk to an attorney that understands your specific situation, because all of our situations differ. So you definitely want to reach out to Dugan and get that one-on-one consultation. If you are brand new to vetting some of these syndication deals, if you're just testing the waters on if passive investing in some of these deals is right for you, you're really going to want to listen to this episode, because we go over basically a legal 101 about a couple things here and there that you need to pay attention to. And so it's really important for people who are new and people who have done this a dozen times. Maybe you'll find something that you haven't been focusing on that you really should be focusing on. So with that, I really want to jump into today's episode and talk with Dugan. But before we get into today's show, I just want to remind everyone, if you're interested in potentially investing in some of these deals that we are talking about, you'll want to head on over to fearfreepassive.com and click that Invest With Us in the top right-hand corner. That'll take you through an investor questionnaire, and we'll see if this is something that is right for you or not. We'll definitely dive into some questions that'll help you understand the deals a little better and help me understand if this is right for you. So with that, let's jump in and start talking with Dugan. All right, Dugan, welcome to the show, man.
Hey, buddy. Thank you for having me. Hey, everybody.
Yeah, I appreciate you being on. I know you have a lot of things you've got going on, so I'm going to respect your time and just start asking some questions. But I think there's a lot of passive investors that have been either commenting on videos or sending me emails or sending messages on YouTube. Actually, that's been an interesting source. And a lot of them have these legal questions that, I'm just not qualified to answer. And I'd say over the last couple of days or weeks, I should say, a lot of them have surrounded the COVID situation. So
Sure.
Let's just start with a basic question. How has COVID impacted you and the investors that you represent?
Right. So we represent a number of investors throughout the country, all the way from the East Coast to the West Coast. And without a doubt, COVID-19 has impacted everyone. So It doesn't matter what state you live in or what commercial asset that you're invested in, whether it's real property or stocks or anything. COVID-19 has impacted everyone. So everyone is in the same boat. And so of our investor clients, many of them, as I'm sure that I'm getting the same questions that you're getting, and that is, what happens in the event that the sponsor or the person controlling my money can't make the debt service payments, right? What happens in the event that the bank says, hey, where's my moolah? You haven't made your monthly payment. What protections does the passive investor have? So I've talked a lot about that with a number of clients and on at other events. And so it's not in a unique situation, Mr. or Mrs. Investor. Everyone is thinking the exact same thing.
Yeah, there's a lot of panic that went on. And obviously the show's name is Fear-Free Passive Investing. So we want to mitigate as much of that fear as we possibly can. And a lot of it is exactly what you touched on, like what happens if my sponsor can't meet the debt? What happens if we need to kick them out, or do I have to put more money into this deal? And so we're going to talk about some of that stuff, but just to back up a little bit, For COVID, and again, we're not giving any health advice or anything. I know YouTube's been cracking down on that a lot lately. I'm sure everyone else is. So we're not giving any health advice, but has COVID changed the way that you're writing these contracts to protect both the investors and the sponsors?
So I would say the biggest change has really been in the area of um, closing extensions, closing timelines, physical due diligence. So if you're a passive investor and you're thinking about investing in the deal prior to March, so January, February, you were seeing due diligence timeframes of 21 days. 2 weeks is pretty fast, right? 30 fairly normal. Now we're seeing due diligence timelines be more flexible. 60 days, 90, 120 days, maybe even just kind of a when can we get in to see the property? And the reason is it's not sellers and buyers are having to work together to find out exactly what's going to work. Because think about it. If you have a shelter and order place for a property in South Carolina and you live in California or you live in New York, the likelihood is you're not going to be able to get out to even physically inspect the property. Your lender to do third parties or physical inspections or what have you, to do the appraisal, that's not happening in a very short, compressed time. So timeframes have had to relax, as well as sellers' expectations of purchase price. So sellers' expectations of purchase price needs to relax as well. And so I'm having existing deals that were under contract come back to the bargaining table with the seller and having to amend those purchase price things. And then, frankly, when does money go hard, right?
Yeah.
January, February, you were seeing a red hot market. So in markets around the country where my clients were playing, Southeast, even in the West, those markets that were really, really hot, you were having to compete, and you were having to compete fiercely with other groups or individuals to get acquisitions under contract and come down hard. And so what that did is that forced the sponsors in a position of having to go back to investors and basically saying, I need to break impounds and use your money, or sponsors having to put more money into play earlier. Now, earnest money expectations have shrunk, as well as the concept of having hard money day one for most commercial real estate assets. Not all, but most have relaxed, meaning there's an expectation that you're not going to be hard on day one. You're going to have a longer due diligence period that's going to allow you to be able to physically inspect the property. And then the closing period, what is that going to look like? And that's going to be longer. So just like at your grocery store where there was everybody stole they bought all the toilet paper, right? We got toilet paper shortage. So it slowed down your time frame to buy toilet paper. So now it's just slowing down the timeline to actually purchase the property. So that's what I could say one notable change in the whole COVID-19.
Yeah, I think a lot of investors have been doing this last few years are used to the quicker timeline. And so for passive investors that are listening, that's one thing that's going to change drastically for you is what was going to be probably a 45-day transaction, maybe a 60-day transaction is now going to be like 120 or even longer sometimes. And especially if you have 120 days due diligence, that's pretty extreme. I've never heard of that. But one of the questions that just to get back to the fears of the investors is what's the downside risk for them in all of this? If they passively invest into a deal and pre-COVID, we'll just call it that. That's like the generational term now, pre-COVID. If they invest into a deal, what's the downside risk for them?
Yeah, so the downside risk for somebody that invested into a deal pre-COVID is you likely had your voting rights. You likely had no voting rights. You were strictly in a passive position. The hold period in your offering, as well as the operating, which is the only document that exists post
Hmm.
offering, right? So that big stack of the private placement memorandum, after you've read through it, signed your subscription agreement, wired your money in, you've received back some either a receipt or a certificate that shows your ownership in the entity that owns the commercial real estate asset. The thing that exists that sets forth the rights and obligations of you as an investor in that entity is the operating agreement. So the likelihood is people that invested pre-COVID, you're in the same position as people that are looking at investments right now, and that is, it. There are no guarantees.
Hmm.
Meaning, the reality is, I'm still a big believer. Although I have clients that invest in all sorts of commercial asset types and classifications, I'm a big believer in multifamily because I still believe that it is one of the safest asset classifications out there to invest in. You're still seeing banks that are still lending, agencies or bridge lenders, and I'm seeing more lenders kind of loosen up and start to think about getting back into providing leverage terms to potential people that are applying for that. You're
Hmm.
seeing still non-recourse debt flow out from those lenders, and they're not dummy, right? So the reality is multifamily investing is still going to be a place where, as an investor, you can still receive
Yeah.
a solid return, and that they're not building any more of it, folks. It's
Yeah.
land.
Yeah.
It's finite, and it will, at some point, in my opinion, appreciate. And
Yeah.
so the reality is, for an investor, you're still seeing uh, cash flow, positive cash flow, and a positive return on your investment from an appreciation play. And from all clients that I've had all across the country, the April numbers that came in, right? The big worry, or the unrealistic fear, because it's proven to be unrealistic, at least as of right now, was that all the tenants, all the people that were in the multifamily tenants weren't going to pay their rent. They
Hmm.
were just going to say, because there's a moratorium on evictions, and most states were saying that they were not going to allow commercial landlords to evict tenants, particularly in the residential context, for a period of time. The tenants would just automatically do the worst thing possible, right? The most selfish thing they possibly could, and not pay their rent, even if they had the ability to do that. And
Yeah.
thankfully, that has not happened. So
Yeah.
we'll see what May looks like and what June looks like, but
Yeah.
I'm still very optimistic.
Yeah, we're recording this a day or two days before May collections start. So it'll be really interesting. Hopefully we're not both wrong about that, because I definitely agree with you. But I want to go back to what you were talking about on the PPM. And for those who don't know, the PPM stands for Private Placement Memorandum. And so I want to talk to you a little bit about what investors need to be looking for in that PPM. I get questions all the time, maybe not questions, but definitely comments about how they're so long and it's full of this legal language. How could I possibly read through this? What are the parts that I need to pay attention to? Now, I know that offends
Right.
you as a lawyer. Like, you can't say, oh, you only have to pay attention to this part, right? But what are some
Yeah.
of the most egregious things that you've seen that people take advantage of, or maybe a couple things that people can just kind of hone in on and look at
Yeah.
if they're identifying a PPM that they might want to invest in?
All right. So a couple of things. If you're a passive investor, if I'm a passive investor, I'm a passive investor in deals myself. I vet deals as the lawyer for private investors. So investors that don't have the time, or they're like what the people that are speaking, they just say, "Man, this is ridiculous. Looking at this thing, it's like 200 some pages long. What is this? All this gobbledygook language, I don't understand it. So they'll hire a lawyer. For investors that don't hire a lawyer, here are some of the things that you need to pay attention to in the private placement memorandum. So the private placement memorandum is simply basically a stack of a bunch of different types of legal documents. They almost always contain the same type of legal documents. The first part is almost generally what is being sold. Most often, if you're a passive investor, you're being pitched a deal that's a part of a LLC, a limited liability company, is being sold to you. That limited liability company is going to be the entity that either currently owns or is going to own a commercial asset, an apartment building, for hypothetically speaking, right? So that LLC is going to own an apartment building. So what's sold? Where in the country is it, right? So the beautiful thing about investing passively in some of these deals are, as a passive investor, it allows you the opportunity to participate in deals in the hot markets in the country and not have to feel like I only have to invest in deals that are right in my city, my state. That's not the case anymore. Our world has shrunk. So podcasts like yours and others that are out there help investors get investors information, as well as connect them to networks of seasoned sponsors and syndicators that allow them the opportunity to participate and look at deals that they otherwise wouldn't be allowed to look at, just by virtue of them not being able to meet people. Right. So passive investors, they meet somebody like you, they develop a good relationship with. Let's say hypothetically you have a deal under contract and it's not in the state in which you live. So one, I want passive investors, what's being sold and where in the country is it? Understand that, right? Because if you're somebody that does not and will not ever invest in the South, and you're being pitched a deal in Mississippi or Alabama or the Carolinas, then right off the bat, the first part of the offering should tell you exactly what the asset is, what the cost of the investment is, and where in the country it is. Okay. Next, I want to know when am I going to get my money back, right? I want to know what is the return or the potential return on my investment, and whether they're offering a preferred rate of return, right? And what is the waterfall, or what we call the plan of distribution? So you might have heard that term waterfall. That just simply refers to the plan of distribution. Money comes into the entity, and then it's going to flow out. First, almost universally, it flows out to debt service, meaning it's going out to pay the monthly mortgage. And then the question becomes, after the monthly mortgage and the expenses are paid, who gets paid what? And so if I'm being offered as a passive investor and I'm looking at that, I'm telling my client, am I vetting that deal for a passive investor, what the preferred return looks like and who shares what after expenses are paid. Next, I'm looking at what are my voting rights. So some deals, passive investors have no voting rights, none whatsoever, none, zippo, nada. And that's set forth in the agreement, which is part of one of those documents that's included in the private placement memorandum. But for me, if I'm a passive investor, I want to have at least some limited voting rights on certain key issues. Well, I know that I'm not going to be managing the asset on a day-to-day basis. If I have a bad sponsor or a manager, I want to be able to boot them out. I want to be able to get together with the other investors and say, you're out. You haven't managed the investment adequately, or whatever the term is in connection with the operating agreement. I want to know, when is the asset supposedly going to sell? What's the exit strategy for this asset? That will likely be specified in the operating agreement as well. So there, it's very important, if you read nothing other than just the operating agreement itself and understanding what your minimum investment would be, that's what I would that's where I would really hone in on, because those pinch points, voting rights, how long is your money going to be tied up, what's your preferred rate of return, and those are the various things that I will look at when I'm looking at it from a passive investor standpoint.
Yeah, and those are all phenomenal as well. And one more to add that I usually say too is the provisions around the capital call. Can you talk a little
That's
bit
right.
about that?
Yes. Great. Thank you for reminding me. Capital call is very important, especially in times where people are feeling fearful, even if there's really nothing to be fearful about. Okay. Take away that. Doesn't matter what your position is emotionally vis-a-vis the current situation with COVID-19. It could be totally unrelated to COVID-19.
Right.
In times of crisis, legitimate crisis, the question for passive investors often are going to be, is there going to be a cash call made? And as a passive investor, you want specific provisions. You want to see specific provisions in the operating agreement about cash calls. And if I'm a passive investor, what I want to see are two things. One, that in the event the manager or the general partner, if you're a limited partner in a deal, calls a cash call, that they've provided proper notice to me, right? So they've either done it appropriately. So there will be, your operating agreement will say the members or the limited partners need to receive notice. Notice is either somebody showing up at your house or your place of work and serving you with a document, right? Those days are long gone, although some operators may just have that. And if that's the case, then you should expect as a passive investor to receive all notices that way. However, most commonly, we're emailing. You're getting emails from the managers and the sponsors. And so that email is effective upon service, meaning keep your emails up to date, passive investors. If you change email addresses, make sure the manager or the general partner has your up-to-date information. Otherwise, it's once they push send on it, even if you don't read it, even if you don't open it, in most situations, you are treated under the law as having received it. And so it doesn't matter if you don't read it. It doesn't matter if you don't open it up. The concept is, if there's a cash call, I want to know, have I been properly notified as an investor, and is the time frame, so typical time frames are cash call in an emergency situation could be called within 24 hours, but most commonly it's between 10 to 60 days, meaning there will be a meeting to discuss the cash call. It's not going to be, you need to give me, X number of dollars within 24 hours or you're out. So most operating agreements do not allow the manager or the general partner to boot you out. So if you were properly noticed and you participate and you still say no, either you say no because philosophically you don't want to put more money into this asset, or two, you don't have it, right? It doesn't matter what the reason. If you say no, but yet whatever the operating agreement has, so if there's a voting requirement and they meet the voting requirement, and so you know that some amount of investors are going to participate in the cash call, you want to know whether you're going to be diluted or not. And most likely, if there's a cash call provision in the operating agreement, it's going to say something like, after the vote of the required interest, whatever that is, 50%, more than 50%, supermajority, unanimous, although likely not going to be unanimous, because if it was unanimous, never have a cash call. You're gonna see after that voting, it's gonna say something like, if you don't participate, which you're not under any obligations to participate in the cash call, the people that do participate will receive extra equity, meaning there will be a redistribution of the existing equity in the entity, and thereby diluting the passive investors that do not participate. Okay. And that seems fair, right? Because you as a passive investor have had the choice, right? And the same choice was given to all the other passive investors. This isn't selectively choosing some people to participate and not others. Everybody's being notified. Everybody's being provided notice. Everybody's coming together, and then everybody's essentially voting or giving their say, depending on what your operating agreement says. And if some people say yes, and they put in their money, and you say no, you don't put in your money, then you're going to be theoretically diluted.
Right.
And that's okay. And that's fair.
Sense.
And I tell passive investors, I want to see provisions like that in my agreement. And as a passive investor, you might be scratching your head and you say, why? Why would you want to see a cash call provision? Well, as a passive investor, the number one thing that I require the manager or the general partner to do is protect the asset. Do not let the asset be foreclosed upon. Never, right? The manager or the general partner has a fiduciary duty to me as the investor, fiduciary duty of loyalty and of care. And their number one goal is protect the asset meaning your money. Now remember, there's one investor in this whole deal, or there's one party in this whole deal that has way more invested into this thing than you. That's the bank. Yep. The bank always has more money tied up in this thing than you do. Absolutely. So if for whatever reason a default is called, a monetary default, meaning there is a legitimate crisis, and debt service, meaning the monthly mortgage is not being able to be paid, the cash reserves have been burned through, the logical choice for most operators is to think about a cash call. If you do not have provisions in your operating agreement that warrant cash calls, or worse yet, you have an operating agreement that strictly prohibits cash calls and prohibits loans or the issuance of new securities, meaning an additional raise after the original raise has closed, then what do you think is going to happen? The bank is going to foreclose on the asset, and you, passive investor, are going to lose your investment. So I, as the passive investor, want to see the provisions of a cash call at least be included in the operating agreement. I want to have some voting rights in connection with that cash call, or I want the ability to say no, understanding that I could, if I don't participate, be diluted.
Yeah, and that's really smart. And you also want to look at it as the sponsor has the foresight to see that that's a possibility down the road. Obviously, you don't want that to happen, but if you don't even have a cash call in your agreement, then it shows that you haven't even thought about that, which shows that, obviously you aren't prepared for what could happen. So like you said, investors should look for that in their operating agreement. But I want to switch gears a little bit too, while we still have a little bit of time left, to address another question that I get pretty regularly, and that's, should investors invest with an LLC or with their personal name?
Right. I get that asked a lot as well. So, and I tell investors, I say, listen, what's the purpose, right? So as an investor, you have very little, if any, exposure in the deal. When I say exposure, meaning personal responsibility, obligations above and beyond what's contained in the operating agreement. The likelihood is, if you're a passive owner of an LLC that owns an apartment building, let's say somebody slips and falls on the property, right? And you're thinking to yourself as a passive investor, hey, can I personally be sued for somebody slipping and falling in the parking lot, one of the properties that I own, or rather one of the properties of an entity that I own? And the answer is almost universally no. You're not going to have much, if any, exposure. Now, remember, anybody can be sued for anything, right? But the reality is that's not the question. The question is not whether you could be sued. The question is, what happens if you are sued. And the reality is most of these deals, the LLC is covered in many, many ways. One, the lender. Remember, the lender has the most to lose in the situation. They are going to require almost universally you to have gold standard insurance in place on the property. And that is always your first line of defense as a passive investor. Second, your operating agreement almost universally is going to say that you as the passive investor have absolutely no liability, none, no personal liability at all to anyone in the transaction. Why? Because you're not controlling the day-to-day operations of the company. So even if you were to hire a crappy property management company or do something that was either negligent or short-sighted or whatever, the manager was, your sponsor, you as the passive investor, personal exposure in connection with that. And most operating agreements are also going to have a key provision, and that's called an indemnification clause. That means, just not unlike other insurance products that you currently have in place, your home, your auto, maybe your business, the company agreement is going to ask both the company to indemnify and defend you, so that in the event that some wacko decides to file a suit against you as the whatever in their scheme, you're basically going to tender. Tender is another legal term of art that basically means I'm going to notify the person that has a responsibility, i.e. the company or the managers, to defend me, to hire a lawyer, to, if God forbid, they need to settle the case, actually pay indemnity, pay out settlement money to the plaintiff. So all of those things put together mean, I tell investors, it's not necessary, but there are certain tax advantages for you as the passive investor to invest through an entity. You could set up a simple limited liability company and hire yourself as an employee of that limited liability company. You might be able to shelter some self-employment tax. You might be able to do some other tax-related advantages, and always operating through an entity, even if you're a passive investor, does provide a good asset protection barrier against even the most frivolous of claims. So conservatively, it's a good idea for you to invest through an entity and not through your individual name, but it's not an absolute you have to, or you're dumb if you don't, or whatever. I think it's a matter of personal choice. It's not a one size fits all. But for me, if I'm a passive investor, I'm investing through an entity, even understanding that it's maybe an extra cost, right, to form an entity that I otherwise wouldn't need to do. But in my opinion, I would do it because it's what's the downside? If lightning or the catastrophe hits and for whatever reason your insurance goes away and all of these other things, having that entity in place is going to be kind of your last resort of your shield, so to speak, from frivolous claims.
Yeah, good advice. I like that. I hadn't thought about the tax stuff too, but maybe we'll have to have a CPA on to talk a little bit about that. But to wrap up here, I want to talk best advice you could give someone who's maybe thinking about passively investing in this. We've had a huge spike in both the podcast listening and YouTube views. So people are clearly using this quarantine time to learn about investing. I'm sure across the board. What is some best advice or best practices that you could give to someone from a legal perspective?
Okay. This may not be strictly legal, but I tell people the biggest hindrance to increasing your wealth in many respects is procrastination, right? To say that again,
wow, really
the biggest hindrance to increasing your personal wealth is procrastination. I can't tell you over the last 20 years of practice how many investor clients that I've had that have said to me, man, if I had just pulled the trigger sooner or bought in my first commercial piece of real estate or invested here or done this, I could be so much further down the chain of financial freedom for me or for my family, right? So I'm a big believer in don't procrastinate. That does not mean jump into it wildly, blindly, without any preparation, without any due diligence. I'm not saying that. What I'm saying is, if you procrastinate and all you ever do is underwrite deals and look at deals, but you never ultimately pull the trigger on a deal, you're going to lose out. You're going to lose out on all of the benefits that come from that. And maybe you don't you don't hit the exact pro forma that you saw in the private offering. Maybe it's a little less, maybe it's a little more, but the bottom line is you will never know. Why? Because you're not playing. You're not in the market. So to the extent, the biggest piece of advice I tell clients is, listen, if it's a bad deal, it's a bad deal. Don't do it. Trust your gut. But if you know the numbers and you know the area of you know your sponsors, you know the area of the country, you like the asset, invest. Don't just sit on the sidelines. So I think that's the one area in which I think it's important for passive investors to understand and take this time. I totally agree with you. There are lots of people right now that they're thinking about, man, what's life going to be like after this? And can I utilize this time effectively? Can I be a good steward of the blessings and the resources that I have in my family to help understand how can I grow my money so that I don't have to rely upon my W-2 employer? How can I passively create diversified streams of income that potentially could bless me, my family, my children for years to come? So, don't procrastinate, but also be smart about it and be informed. And so gathering up, being educated, learning about this, and then ultimately taking that leap of faith, because your deal, your first investment, it's all going to feel, you're all going to feel anxious about that. That's normal, but you got to get past that. You got to push through that, because ultimately I think that you're going to find that you're going to be largely blessed in connection with investing in real estate.
Good, really good advice. And I'm glad it wasn't necessarily legal advice, because I should have given you that option too. But that I 100% agree with that. Just not procrastinating and being consistent are my two huge pieces of advice to anybody. And so I totally agree with that. But just to wrap up, I have probably 1,000 questions for you, but we'll have to have you back on. If people have questions, or maybe they want to have you look over a PPM or vet a deal or get some advice, where can they reach out to you?
Yeah, we're all over the place. Typically, I'm traveling all over the country, speaking at conferences and events and seminars on real estate and investing. Now, you can certainly reach out to me by telephone. You can find me on the web. We're at Kelley Clarke, Kelley, Clarke, CLARKE, law.com. Or you can email me. It's my first name, Dugan, Dugan, at Kelley, Kelley, Clarke, CLARKE.com. Send me an email, shoot me a call, be happy to help you.
Great. Yeah, all that will be down in the description and also at fearfreepassive.com. Dugan, thanks so much for taking the time. I really appreciate it.
Thanks, buddy.